November 25th Administrative Conference is now called to order. If you would, please stand. Put your cell phones on silence or vibrate, please. I'll open us with an invocation, followed by the pledge by Councilwoman McCullough. Heavenly Father, we appreciate the opportunity to be here today. Please keep those citizens who have to be outside, whether through work or those who are outside friends and citizens, keep them warm. Let them find a warm place to be. Keep them safe. Lead us to make good decisions today, good conversation, and do business for the good of all the citizens. Amen.
Amen.
Would you turn and face the flag, and let's repeat the Pledge of Allegiance in unison. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, will you please call the roll?
Ms. McCullough? Here. Mr. Everson? Mr. Oliver Jenkins?
Present.
Mr. Corbin?
Here.
Mr. Webb?
Here.
Mr. Shine?
Present.
Mr. Sam Jenkins?
Tomorrow, I will entertain a motion to approve the minutes of Administrative Conference and City Council meeting, because there's no dates on my script of the last meeting. We will do that. At this time, does any council member have any awards, recognitions, or distinguished guests?
Just a lighthearted, good to see the LSU Tigers play a football game finally.
Yeah.
Yes. Very much.
Good game.
I think they could have beat anybody Saturday. So.
They definitely would have given anybody a good one.
They certainly had it together. Well, Mr. Sibley.
At this time, Mr. Chairman, nothing pending. The mayor may have a few observations when he comes down.
Okay. All right. Sounds good. Is there anything relative to property standards that council has a concern about? If not,
Hold on a second.
We'll take up property standards appeals at the end of the meeting.
Okay.
Thanks, sir. Let's see. We do have a public hearing tomorrow. Mr. Thompson, would you read the information relative to the public hearing?
We'll have a public hearing on resolution number 208, which will state the City of Shreveport's endorsement of Home Federal Bank to participate in the benefits of the Louisiana Restoration Tax Abatement Program. I believe that there will be a presentation by Community Development,
That's
Ebony,
correct.
I believe, on tomorrow, to go over the details before the public is invited to speak.
Okay. Thank you, Mr. Thompson. Mr. Sibley, is there any legislation to be added tomorrow?
Yes, sir, Mr. Chairman. There are two indicated on the agenda. Resolution 212. Go ahead and read it, Mr. Chairman.
Sure.
A resolution to repeal resolution number 133 of 2012, which authorized the execution of a cooperative endeavor agreement with the Red River Waterway District relative to the construction and maintenance of a dog park on land owned by the City of Shreveport adjacent to the Red River in Shreveport, determining that a project to construct and maintain a dog park on city-owned property adjacent to the Red River to be infeasible, encouraging the exploration of cost-efficient options for construction and maintenance of a dog park at other locations within the City of Shreveport, and to otherwise provide with respect thereto. There's also number 213, a resolution expressing no opposition to the waiver of section 26-57 of the Code of Ordinances, reaffirming the findings and the directives of resolution number 120 of 2013 regarding the collection of overcharges from the 2011 general obligation bond election, and to otherwise provide with respect thereto. Mr. Chairman, there are two others that are not indicated yet that we will submit on tomorrow and ask that they be added. One would be a legislation regarding the DDA program of work and budget, so that the council will be in position to go ahead and move forward as a part of the budget proceedings. And secondly, we have a grant for the fire department of about $35,000, and we'll offer an amendment to the grants budget to accomplish that matter.
Thank you, Mr. Sibley. Any questions?
How is this?
Well,
Go ahead.
No, go ahead. No.
Well, I was just looking at the items that were being added on. Resolution 212 that's going to be added on. Is it my understanding that some further discussion may be taken? I know we can't talk, in open session too much about it, but is it my understanding some further discussion is underway concerning the dog park situation between the parties? Am I the only one being led to believe that some further discussion is going on
I think
concerning
we
this?
got an email sort of saying that there was, what was that? It was saying that the Dog Park Alliance may be interested in other solutions along the Red River.
Amenable, I might say.
Amenable, yeah.
To other
Okay.
locations.
Okay. Now, I don't know how that new development is going to be treated with all this. I know we're trying to put this off for tomorrow, but, I mean, speaking for myself, I certainly would like to know if that's a discussion that's going to, be taken up before we have to actually move on Resolution 212.
I was hoping that we could get some information from Councilman Oliver Jenkins before we.
I'm not sure I know of anything. And, of course, my iPad was working this weekend, and Councilman Shines might not have been, but I think we were all on the same email. I think what they're saying is that they're not necessarily, it's not either Hamels Park or nothing, that they might be interested in looking at some other areas that might be more cost-effective and that may meet the budget. At least this is what I understand.
Yeah.
That currently is provided in that Red River Waterway Commission fund. So I would just say, based on
Isn't that
that
in your
email,
area? I mean, isn't that a part of your district?
part of it is in my district, and then part of some of the other sites may not be in my district. Isn't that correct? Isn't
Yeah, I think
Stoner
one
must
of
be,
one that was mentioned was Stoner, which is in my district.
and then the other part of it that I do, from Sam's point, I guess on some level, I would think that that particular ordinance would be premature given light of this new opportunity, in my mind. But I don't know the whole details. My email was from city attorney, I believe.
And I guess that's why I'm asking the question, if there's going to be some further discussion on it. I know it's just up to be added onto the agenda, but if there's going to be some further discussion, I would like to have the benefit of that further discussion. I'd like to know what's coming out of that before we actually act upon what's being proposed. All that may be a discussion for tomorrow, but I guess I'm just sending some signals out one way or the other.
I think there will likely be more discussion held tomorrow.
Okay.
I would hope that in our discussion and selecting if you select a new site, I would hope that it would not be close to a residential area.
I think, I guess my point is I'd like to start over and re-examine a lot of different locations at this point before shutting out the waterway funds. As long as we found some opportunity to use those funds in the manner in which they're intended, I'd like to move forward in that regard at this point. Because I certainly don't want to do something that's maybe is a higher budget than we initially envisioned.
And I bring that up also, Mr. Chairman, because I don't know what the deadlines may be involved with the litigation. And I don't think we need to leave that out of the mix of all this. I'm not sure what those deadlines are, when some decision has to be made. But I do know the courts run their own calendar. We may be needing to decide something before that litigation get to a certain point. So I guess I'm asking someone hopefully can fill us in on the new development and what impact it would have on all this. If any, I don't know. And then we can hopefully know which direction to go with this particular item that's on the agenda.
And I do feel, I do feel certain there will be additional discussion tomorrow. There may even be additional presentations made that will help with the decision, whether we add it to the agenda or not, but certainly before we would take any action on it. Mayor Glover.
Thank you, Mr. Chairman, members of the council, and Councilman Sam Jenkins. Thank you for asking the question, because we certainly believe, whether it's today, tomorrow, or both, that there is a need for additional discussion. I think Councilman Oliver Jenkins made reference to the fact that each of you all should have received an email at some point, either over the weekend or late last week, that would have come from the city attorney in reference to contact that had been made to her by Mr. Dan Keel, representing the dog park folks, indicating their desire to have some discussions regarding the resolving of this matter. I am firmly convinced that that inclination is as a result of the executive session that this council held with 4 of its members on last Monday, where we followed up on discussions that I think that we initiated with you all at least as far back as September, if not earlier, indicating that we believe that this was a matter that needed to be resolved, could be resolved, and that it was time, in fact, to do so. We indicated to you at that time that we saw this needing to go in either one or 2 directions. Either action by this council that acknowledges that the funds appropriated by the Waterway Commission were less than half than what was required to stand up just the basic dog park. There was some concern expressed as to whether or not those numbers were in fact factual and correct based on staff estimates, and we were requested in turn to seek additional information from quote-unquote independent sources. It took a bit of time to get that done, but it turned out that those 2 independent sources indicated a cost that was even higher than the projections that had been established by staff, and that did not even include some contingencies like engineering, design, a reserve fund, and what have you for the project. We have suggested 1 or 2 points of a resolution between the administration and the council, which we believe we can accomplish. And that's embodied within the context of Resolution 212 that is before you. That particular resolution has even been changed from its original form based upon feedback and input that we've gotten from council members, both within that executive session and before and since then. And we offered it to you all for your critique, adjustment, concern, and what have you. The other was for some member of council, and we provided a sample budget ordinance as well that would establish the project and to indicate where the funding necessary to fund the project would come from, and whether or not you felt that you had any ability to be able to pull together 4 votes to be able to actually fund the project. At that point, that would put me in the posture of having to decide whether or not that would be a project that the administration and a process that we could support, ultimately maybe even sign off on. We've not gotten any additional feedback or response with regard to either the idea of a council member establishing a capital project or any further versions of a resolution. Essentially what the resolution does is that it renders the basis of the lawsuit null and void and allows us to be able to move forward with whether it's dog park or any other interested groups in determining where we can seek to locate a possible off-leash dog park area somewhere within the city of Shreveport. That's essentially what it does. What you have specifically gotten back from the Dog Park Alliance were the expressions that were offered to City Attorney Anderson Scott on last week. But then that has also been further detailed, and I guess since I'm on Twitter and some of you are and some of you aren't, I tend to assume that what goes out on Twitter under an official handle is considered to be in the official public domain, Councilmember Webb. I know your iPad is about as, or your Twitter account is about as active as Councilman Shine's iPad, so.
Yeah, I don't get it.
So I'll go ahead and share what the dog park tweeted this morning. And the first tweet, and there were two tweets that were sent out by the Shreveport Dog Park Alliance. The first one says, Stoner addresses all concerns of Mayor Glover, question mark, a fence, some gates and amenities from the private sector make dog parks doable. The second tweet read, following Mayor Glover lead, Shreve Dog Park, Stoner, everything a dog park needs and then some. And so, based upon the communications that came from Dan Keel over last week, and those expressed communications that came in this morning, and as well as some additional feedback and dialogue that I understand is going on, I do believe that the dog park folks are of the mindset that this is a situation that now needs to move away from Hamels. Even that singular consideration calls for a nullification of the resolution that is at the foundation of the legal dispute that is in question right now. And so it goes back again to, because even the consideration of a Stoner location or any other place for the use of Red River Waterway Commission funding or some other source would entail doing away with the very specifically drawn, and that's part of the problem that we've expressed to you guys all along, is that what was included and drawn within Resolution 133 of 2012 was not in the best interest of the city of Shreveport, and specifically limits the ability to be able to act in a way that protects the interests of the city. And so a process going forward, from our perspective, entails ultimately having to resolve that issue and going forward. We specifically, from the administration standpoint, have outlined what we consider to be an appropriate path forward. I think it starts, Mr. Chairman, members of the council, with firing the lawyers. Let's stop the clocks from ticking and save the citizens of the city of Shreveport any more financial exposure on this matter than what they have already experienced. That's why we reached out to you guys several months ago. That's why we're continuing to do so, because we believe that this is a matter that has to be defended and addressed in order to protect the interests of the city. But it can be resolved without the need for continuing to retain legal, at least outside of legal assistance with regard to the lawsuit. And so we would ask that we get a chance to fire the lawyers and address and resolve this matter between the administration, the council, the dog park, and any other interest groups that are out there that want to play a role in that. What that entails is either one of two things. The dog park folks agreeing to dismiss the lawsuit, or this council taking action in line with Resolution 212 or something to that effect, but that ultimately rescinds the effect and impact of the resolution of 133 of 2012, which again serves as the basis of the legal issues at play here. The number two on our list is to share the details of the executive session conversation from last week, which I just did in part. I think that that's information that the public has a right to know and have access to and be aware of, so that they can know exactly what type of implications are at risk and at stake in terms of this overall situation. And I would assume that based on some of my earlier comments, at least to a certain extent, I've already done that. Essentially, to be more specific, there was a request for alternate cost projections for a dog park at the Hamels Park location. We acquired those two projections. The staff projection for the cost of a dog park, Councilwoman McCullough, was $580,000, some $300,000 more than what was provided through the Waterway Commission. The first independent cost projection acquired came in at $640,000, some $60,000 more than even the staff had projected, and well over $300,000+ more than what had been provided by the Waterway Commission. The second cost projection, council members, came in at $690,000, $110,000 more than the staff's projection for the cost of a Hamels Park dog park. And again, hundreds and hundreds of $1,000s more than the $280,000 provided by the Waterway Commission. And it did not include either a contingency fund for the project or the expense of the design fees in either one of those. So those both numbers, 640 as well as 690, would have been at least appreciably higher. The third step forward, council members, we believe is to engage staff, SPAR, and Shreveport Police Department and others to review the Stoner location. It has been reviewed before. There were recommendations to avoid that location because of some concerns. In fact, one message I got earlier today was specifically, and I'll quote, the Stoner Hill Pit Bull Owners Group Association looks forward to welcoming the dog park to the neighborhood. But now, again, that's a part of what we allow staff and SPD to review to see whether or not those issues and concerns can effectively be addressed. I would offer, in the interest of full disclosure and transparency, that when this particular location came up for initial review, there were some factors existent at that time that were not existent, that are not existent now. At that time, we were still operating the marina as a restaurant in that area. That particular facility has now been leased to the sheriff. We have a cooperative endeavor agreement for the sheriff, Kettle Parish Sheriff's Office, marine detail to be based out of that location. So we have a law enforcement presence that is there now that was not there then. You also have the Riverscape development that is opened up across the street. So there's a different dynamic in place right now, environmentally speaking, than may have been there before. Fourthly, Mr. Chairman, members of the council, I would encourage us to engage the members of the Red River Waterway Commission and encourage them that if ultimately there is a decision between the administration, the council, and the dog park interest, that Stoner represents the best location for a dog park development. Our request would be that the Red River Waterway Commission manage this particular project at this location in the same way and manner in which they have managed all of the other Shreveport riverfront funded projects by the Red River Waterway Commission. And essentially, if you all will recall, you recently approved the engagement of the Waterway Commission in a relationship, a cooperative endeavor agreement that will expend over $1 million doing improvements and upgrades to the Riverview Park area. All of that spending in terms of selection of professionals, going out for bids, managing the construction and what have you, will be done by the Red River Waterway Commission and its staff. Once it's completed and effectively inspected by the city of Shreveport and deemed in line with our agreement, it will then be transferred in its entirety over to the city of Shreveport for its management, oversight, and upkeep. But any potential cost overruns or other projections or other issues rather that were not initially projected are being and will be addressed and managed by the Waterway Commission, just as they did with the original manifestation of Riverview Park. As they will do with these improvements, we would suggest that same protocol be put in place in the event that we construct a dog park at the Stoner location. That would put the Waterway Commission responsible for those improvements in the same fashion as they are for the improvements currently being funded for Riverview Park, and ultimately will result in a limiting of the exposure of the citizens of the city of Shreveport in terms of the capital costs of that project and any other aspect that would go along with its construction. And then lastly, Mr. Chairman, members of the council, the potential of a Stoner location also represents, again, assuming that these other issues and concerns can be resolved, an opportunity to even further lessen the burden on the taxpayers of the city of Shreveport when it comes to its operation and maintenance. Since there's already a sheriff department located marine facility that is currently staffed. Obviously, the sheriff has also indicated his support for the dog park and what have you, and because the sheriff also has access to inmate labor that can be effectively managed and directed towards various tasks and functions. We would ask that they would take on the duties and responsibilities of operating, maintaining, cleaning, and what have you, the dog park itself, again, alleviating that duty and responsibility from the taxpayers of the city of Shreveport, and allowing us to be able to provide an opportunity for those folks to engage in some activity that would be a positive contribution to society. Essentially, since we know, for folks who keep up with the film business, the television show Pit Bulls and Parolees is currently being filmed out of New Orleans. We might be able to convince them to come to Shreveport for their next installment and have them located at the Stoner Avenue Sheriff Department, City of Shreveport, Kettle Parish Dog Park.
Except for that pit bulls are not allowed in dog parks, obviously. By our resolution. I mean, by our ordinance.
I didn't know we were discriminating against breeds. I have to go back and reread it.
I believe that is included in there. I could be wrong. It's been a long time, but it is, I believe, addressed in it.
Well, I guess speaking for those large mammals who are sometimes perceived as being meaner than their actual look and demeanor, I express a little empathy and sympathy.
Well, I do recognize your views on this, Mr. Mayor. I really do. And I know that it's something that you thought out very clearly. But I think for the first time, I'm hearing that the Dog Park Alliance is willing to discuss an alternative site. Everybody had their lines kind of drawn in the sand, and one of theirs had to be Hamels or nothing, but I guess I'm hearing for the first time that they are willing to consider that. And I guess what I want to know quick, fast, and in a hurry is if we move forward with Resolution 212, does it basically end the litigation, start this discussion about a dog park all over again, and if so, by who? Mayor's office, the Alliance, the council, or the Alliance, or the Red River Waterway Commission, even the parish for that matter. I don't know who all needs to be in on that discussion. If we do not move forward with Resolution 212, does that mean that, this discussion plays out in court? We don't know what that decision may be. Judge could say it's something that has to be enforced. I mean, where does that leave us? What do we have to do? Judge may say, well, maybe that ordinance is not enforceable. Does that bring us back to the same discussion we had today? I would just really love to know if those discussions that are now going on about an alternative site, can some time be given to talk about an alternative site, the pros and cons of it, as well as if there's any kind of concerns from SPAR about a location like that? And is it something that can be done within the funds that's already been authorized by the Waterway Commission, as opposed to anything else? I guess I'm just trying to see, is there going to be some time where the new development can be discussed before we have to act upon a resolution?
Mr. Chairman?
Mayor.
I think regardless, Councilman Sam Jenkins, of where the new discussions go, the resolution of the Hamill situation and the litigation involving it needs to go away. Because it, again, as I've stated, I believe the position of the administration is correct and necessary for exactly the reasons as to why we are here right now. What we have established and alleged all along was that Resolution 113 of 2012, one, it is, I'm sorry?
You said 113?
No, 133 of 2012.
Okay.
As referenced in Resolution 212 of 2013, under 7A. That represents the first resolution that's known to have been passed by a city council of the city of Shreveport, a body that 35 years ago tomorrow was first founded and impaneled. It's the first time in that span of time that there's ever been the passage of a resolution with regard to a contract that was not a permissive one, an authorization. That is the usual custom in which the council has conducted this aspect of its business, recognizing that when you, if you were to attempt to say specifically, you are required to sign this specific document, it takes away the ability of the administration to address and resolve the very kinds of issues and concerns that we are in the midst of right now, and which specifically detail why the Hamels location and this overall situation is not ultimately in the best interest of the city of Shreveport. Because as you all have seen in reading Resolution 133 of 2012, it is specific to the Hamels location. It specifically states that any funding that is not sufficient enough to be able to construct a dog park location will have to be provided by the city of Shreveport. All of that, despite the fact it is clearly established that the amount of money that was requested from the Waterway Commission was in no way representative of the actual cost needed to construct a dog park. And so part of what is, we believe, the appropriate role for a mayor and an administration is to be able to act on those types of issues and concerns, if for no other reason than to be able to go back to the entity that we're looking to engage contractually and say these terms need to be adjusted. We need to either nullify the portion that says the city is required to come up with additional money, or we need to negotiate with you guys to get additional dollars, or we need to have some flexibility on the location. We need something. But that was not the course that was taken. And I could probably sit and attempt to try and account for why I believe that to be so, but being that as it may, it's where we are. We have a resolution that says that the mayor shall specifically sign this cooperative endeavor agreement obligating the city of Shreveport to these specific set of circumstances and conditions, all of which are not in the best interest of the city.
You believe that this resolution 212, I just want to make sure I understand the administration position. You believe that this needs to be addressed before there can be some discussions about a new location? Is that
Well,
what I'm understanding?
I believe either that or someone identify what it is that the council intends to come up with another several $100,000. Because what has clearly been established is that you cannot build a dog park at the Stoner Hill location for anything under than $600,000+, which is several $100,000 more.
The Hamels location.
At the Hamels location, I'm sorry. But you cannot construct a dog park at the Hamels location for the amount of money being provided by the Red River Waterway Commission.
$250,000.
$280,000.
280. Oh, okay.
I would like the record to note that I disagree with that statement, because all we've been provided is a document says to have all the amenities that we collectively, or SPAR or you, believe need to be there, make it in excess of 283,000 or 281, to whatever that number is. Now, I'm not disagreeing with those choice of amenities, but I mean, clearly we could do a dog park there for less than $280,000.
That's not correct, Mr. Jenkins.
And what?
Because as was requested of staff and was requested of the other folks to come in and provide the alternate bids, based on best practices, what is a basic dog park? Understand, I also believe that a basic dog park should have bathrooms, that it should be ADA accessible. that it should have a playground, and those sorts of things to make it a complete facility. But the cost projections that were provided to you and the other members of council are not for any of those things, Mr. Oliver Jenkins. It's for a basic dog park at the desired location and specified location of both this council and the desired location of Shreveport Dog Park Alliance.
I hear what you're saying. I do not believe that every amenity listed under that 600,000 is required of a dog park. Now, you are using that particular added little clause that to follow under best practices. And I'm not really an aficionado of dog parks, so I'm not sure what best practices are, but clearly there is the one line item that is indisputable in there is the requirement of a cost of a fence and a gate. And that budget line item under both of those project numbers is less than 280,000. So I'm saying, I'm not saying that that would be how we would build a dog park. I am saying that if somebody could argue that that is the bare minimum of what it costs to build a dog park.
And in the midst of all of this discussion, Mr. Jenkins, neither you or anybody else in the dog park has come up with an alternative proposal. What we have done is ask staff, in your considered professional judgment, establish this project that's just as you would any other capital park project. And that's what they've done. Don't make it any fancier, don't make it any greater, don't make it any more illustrious than what it needs to be, but make it what it is that it ought to be. Cost that out and give that to me and the council and the public so that we can make some appropriate decisions. And that's what we've done. We were also asked to go out by members of this council and seek independent evaluation of what those projected costs would be. And we've done that as well. Both of those have come in at considerably more than what even the staff has developed. What we still get back from you, Mr. Jenkins, is what you offer here today with nothing more specific than that. Which makes it pretty hard to take action on.
My only concern going into tomorrow is I'm trying to get a good handle on really one thing, to be honest with you. Is it worth an investment of time to talk about a new location and hold off on voting on this resolution 212? That's really what I'm trying to find out. Now, if the ends doesn't justify those means, then I guess we need to look at what we need to do tomorrow. But I would think, if I'm hearing for the first time, that the Dog Park Alliance is saying we're willing to look at another location, and I don't know what all those specifics are now. I don't know what it's going to cost. I don't know if that's a viable place. I don't know if there's some objections from SPA. I don't know what all those concerns may be. If I'm hearing for the first time that they are willing to look at a new location, do we invest a little time in that discussion? I'm wondering if that discussion is taking place, has it been engaged? I mean, is it a viable option at all to what we're doing? It might not be, I don't know, but that's what I want to know. That's what I would like to know. Because if we vote for this tomorrow, basically we're just saying the idea of the project at Hamels is not feasible. Basically is what we'll be saying, and that's it. There will be nothing, there will be no further step in the direction of a conversation or a dialogue about the dog park. The suit will kind of be moot. Maybe a repealed ordinance that we went forward with, but where does that leave the discussion of a dog park, you know, at that stage? What happens with that discussion, I guess?
Mr. Chairman, Mr. Jenkins and Councilman, that's why I kind of outlined those 5 steps that I just laid out for you. From our perspective, because to go back, you know, we were the ones that asked for the postponement before the Second Circuit, because I said to staff and I said to you guys, you know, we can settle this. We need to settle this. We need to resolve this, and we need to do so and as quickly as possible, because it continues to do what it's doing, and that is questions are asked, but nobody ever wants to act on the answers. And so let's just postpone it, you know, stop the clocks ticking on the lawyers, tell them to stand down and give us an opportunity to be able to introduce this information here to the council and to the public and make some decisions. What's absolutely known? The basis for the $280,000 came from bad information. Okay? That came from a request from Randy Lucky with the parish of Caddo, who joined council members Oliver Jenkins and Jeff Everson and others who went before the Waterway Commission to make this request. That $280,000 was clearly indicated that this is not the actual cost needed to construct a dog park. But that commitment on the part of the Waterway Commission is what started us down this road of believing that we need to take the action that was taken in 133 that says, let's establish this project, go forward, enter into this agreement, and build a dog park. What we did was ask for the Second Circuit to extend the length of time before our response and the dog park's response is into them, so that we can attempt to settle this without any further legal expense and exposure to the city of Shreveport. I think it has clearly been established, based on the fact that even the cost amount, or the amount that was requested of the Waterway Commission, was in no way reflective of the actual cost of constructing a dog park at Hamels. That's established. That's clear. We've now also been able to establish, Mr. Jenkins, based from 3 sources, staff and 2 outside sources, that the actual cost for that is somewhere approaching $700,000 plus, $640 on one, $690,000 on the other. That's information that we shared last week in executive session with the members of this council. We also now have heard directly from Mr. Keel to City Attorney Terry Scott on last week, in an email response from the city attorney back to Mr. Keel, myself, as well as members of the council, to make us all aware, keep us in the same circle at the same time, that we acknowledge, wanted to hear from them what their thoughts and ideas were. I think the specific request that they do so before 2 o'clock today, so that we would have that information and be able to use it as the basis for our discussions both today and tomorrow. As I understand it, that response is in part represented by the sentiment that's been shared. They called Kirsten Holmes at Channel 3, did a story. I guess, we talked to the media, but I guess that's an effective way of communication. I saw Mr. Keel was actually interviewed within that story. Not the most direct way of talking, but that's part of the way the dynamic works and goes forward. Clearly indicating their interest in investigating the Stoner location as an alternative. What we would do is engage them, staff, and any other interested parties in the process that would be appropriate for evaluating the Stoner location for a dog park. There's a requirement that ultimately, as it currently stands under our ordinances, is that if that's a location that they're interested in, I think they would ultimately end up expressing that to the administration and the council, and then we'd have an opportunity to be able to act on that as a possible scenario. That would involve obviously input from staff, from the police department, and other stakeholders involved with it, and then we would review and evaluate it from there. At the same time, it would be necessary, I think, to entertain dialogue with the Waterway Commission about whether or not that would be a change that they would be amenable to. In the process of doing so, as I suggested in one of my 5 points, I think we should also discuss with them the possibility of their treating this particular waterfront or river improvement project in the same way. Let's not discriminate against the dogs. Treat it the same way that they have the Riverview Park improvements, and I'm assuming the other projects that they've engaged in other communities along their area, and let them not only fund it, but manage it from a construction standpoint, from a cost standpoint. So if there ends up being any additional cost overruns above what is understood and agreed upon, then that ends up being the responsibility of the Waterway Commission. and not the city of Shreveport. And then once those improvements are completed, if they're done there at the Stoner location, then that becomes, again, a project like Riverview Park that the city of Shreveport would be responsible for managing. The additional part that I added that I think adds some degree of consideration is the fact that the sheriff is there now. When he wasn't there, when this evaluation process began several years ago, as the dog park folks and council members and others began to look at different areas along the city's infrastructure, and it would be a good opportunity to be able to lessen the burden on the city of Shreveport if some of those folks that the sheriff has under his supervision could be the ones ultimately held responsible for cleaning and scooping and maintaining and clipping and trimming and what have you. And again, in that we are a filmmaking community right now, I thought it might also be a good opportunity to be the next installment of pit bulls and parolees. But according to Mr. Everson, it might have to be chihuahuas and sheriffs, I guess.
I picked up the rules, and evidently I was wrong on there's a description of what type of dogs, because obviously before you go to a dog park you have to buy a tag and a permit to enter the dog park, and in that process they screen for if the dog is aggressive or not and that kind of thing. So I was thinking, I remember at some point in that discussion, which keep in mind was like 3 years ago, there was some idea of not allowing pit bulls, but I don't believe it made it into the final draft. But I think there is some
Not exclusionary.
so you'll be happy to know a well-behaved pit bull seems to be allowed.
And again, on behalf of aggressive-looking large mammals, I say thank you.
Councilwoman McCullough, did you want to weigh in on this topic?
Well, based on everything that I've heard, it seems like the information that was provided by the mayor and administration, the cost studies, it's 3 of them, supports the resolution that's on the agenda today. Is that correct? I mean, this supports the resolution?
It is the basis upon which we believe that action would be proper and appropriate. Because in order for any of this to move forward, we need to resolve the legal matter that's at play. We've had an entity outside of the administration, outside of the council, that has sued the administration, me personally and individually, to compel me to sign off on a matter that we believe would end up ultimately resulting in the detriment of the interests of the city of Shreveport.
Which you previously advised after they requested to be advised as to whether or not this was going to be a project that we could take on. And based on your public hearing that I attended, it's my understanding that they were informed that we were not financially stable enough to take on this project. Is that? And so with all the figures that are going now, that still supports the fact that financially we're not going to be able to.
I guess I would alter that just slightly. Financially, this has nothing to do with the fiscal health of the city of Shreveport. What it does have to do with is the wise and prudent use of the fiscal resources we have a responsibility for. And that is, in order to be able to comply with the construction of a dog park at the Hamels location, then we would ultimately end up taking from some other source that would otherwise be available for use at some other public facility that capital dollars could be used for. We would be using those capital dollars to supplement the expense of constructing a dog park. And that's after it has been expressly stated from the discussions before this council, going all the way back to September of 2011, that there would not be any additional public dollars expended for the construction of a dog park, that those would initially expressed to be private dollars. It was also the same conversation where we discussed the need for the design standards to be wrought iron as opposed to just simple chain link fencing, and that was a sentiment that was shared in and expressed by all the members of council who commented.
So am I hearing a recommendation from administration to postpone this resolution until all parties involved come to the table to maybe look at another location, which that hasn't been done?
No.
Okay.
What I'm suggesting is that one of two things happen. We need to, because we requested a postponement before the Second Circuit, but that postponement is until, Attorney Scott?
I think it's Monday.
Second, so it's until next week. And if that doesn't happen, then we need to advise the attorneys that they need to actually, again, begin to start back up the clock that will result in their hours ticking, preparing the necessary documents to be submitted before the Second Circuit Court of Appeals to deal with this matter. My suggestion is that we not allow that to happen. Part of what, one of two ways in which that can stop, and that is either the party who has filed the suit agree to withdraw it and dismiss the lawsuit, or this council can take action that actually takes away the actual basis for the lawsuit. The basis for the lawsuit is the fact that, as mayor, I do not believe that Resolution 133 of 2012 is in the best interest of the city of Shreveport. That it is a very bad piece of legislation that should not be complied with. The Dog Park Association has sued seeking to compel me to comply with signing that resolution. Action by this council that rescinds the resolution essentially takes away the actual basis of the lawsuit.
And that's a question that still
I was going to ask.
lingers
Like
in
they
my
give you
mind.
power to do something, and then when you exercise that, it's like it's still not working.
Well, I believe that the signing of the cooperative endeavor agreement that's called for in Resolution 133 of 2012 results in the harm, the detriment of the city of Shreveport, and creates a set of circumstances where the level of exposure is unacceptable. It also is in bad form in that it creates the precedent for a requirement as opposed to an authorization, which again takes away the ability of not just this mayor and this administration, but any mayor or any administration to be able to effectively and appropriately interject itself into the contract process for the city of Shreveport. Because if we had the ability to do so, if that latitude were afforded within this particular resolution, then the issues that we are discussing here today would be ones that we could in fact address through an effective negotiation with the Waterway Commission. We could possibly be able to change locations. We could possibly be able to determine whether or not additional funding is available. It would be possible to be able to give consideration to the project shifting to them being responsible for the engineering, the designing, the constructing, and what have you.
If we pass this resolution.
If we had not, if the council had not passed it in the way that it has. The reason as to why we believe this resolution needs to be passed is so as to basically nullify the council action from 2012 with regard to Resolution 113 or 133.
I can support that.
Will a repeal of that original ordinance, I mean, will it have, can the court still take up the question that's before it though, even though we're repealing the original ordinance? In other words, the original ordinance is what before the court, that's what they're considering, no question that comes out of that. We're coming after the fact, so to speak, and we're changing it. That's a question I still don't know the answer to.
Can we change it?
Well, I'm just saying, if we change it now, can the Court of Appeals still consider the question that's already pending there? Or does this new legislation make that lawsuit moot, so to speak?
But I'm not a lawyer. I'm not going to play one on television. I do know if I were a lawyer, my desire would be for that to answer that question to be no. Because what that results in is the ability for this situation to keep churning additional billable hours for lawyers. But I'm of the mind from just a common sense Cooper Road perspective, and that is if the basis of the lawsuit, if the reason as to why the lawsuit is here has now been nullified by the very same body that passed it in the first place, then the basis upon which the plaintiff is here and what we're being asked to take valuable court time to address no longer exists. I would also hope that in the meantime, that process is going forward, that the dog park folks would avail themselves of the option to be able to have the lawsuit itself dismissed as well. But that's nothing that I can control or guarantee, and in fact, it's only been since our executive session on last week that there's actually been an indication on the part of the dog park folks to entertain any other consideration beyond what was called for in Resolution 133.
Dale, Mike looked at me and asked, kind of wanted to get my legal opinion on it. I told him I'd kind of stand down.
Can opt out of that one, Mr. Sherman.
But with regard to that question, I would ask, you have Julie, who's there, representing the council. You have City Attorney Scott, who's out in the audience. I'm not a lawyer. I would ask those folks to speak as well.
Does anybody ask?
If we can nullify it. I mean, if legally we can nullify it, is that the question?
No,
What would be the effect?
yeah. The question would be, I think what the question would be is, there's already a question pending before the Court of Appeals. We are coming later, and let's say we support this and repeal that ordinance, that's the basis of the question. Can the Court of Appeals still take up the question that's pending before them?
I probably would call on Ms. Scott, since this is in litigation that I'm not handling. I do have an opinion on that, but maybe I should let the litigation attorneys answer that.
Mr. Jenkins, what I will say is my typical statement to you. This is still a matter in litigation, and the specific answer to that question is one best discussed with you all in private.
And then I have a follow-up to that question. If for some reason we, the city administration, made some proposed amendments to CEA that were palatable to both parties, that be the city and the, because cooperative endeavor agreement is parish or with the Red River Waterway Commission, I can't.
The city and the Waterway Commission.
Okay, so if at this point the city made some proposed amendments that said in lieu of Charles and Marie Hamill's park, it was another site to be determined on the Red River Water, could that be a potential resolution if all parties agreed to that?
Right now, anything is wide open and possible. The original resolution that was adopted, the 133, authorized the execution of the contract that would permit a dog park adjacent to the Red River. What this resolution that you are considering, I believe it's 212, would allow you to also consider other locations and sites for a dog park in addition to those along the river. So that's the big factor here in regard to 212. It allows for consideration of other sites for a dog park.
Well, but the mayor's point is valid, that in the actual CEA, as well as in at least one of the clauses of the resolution, it does specifically say Marie
At a site in Claude and Louisiana.
Maria Hamill's Park. So obviously, the way I read this, we're eliminating the resolution of the resolution, if we repealed it, doesn't exist anymore.
Correct.
At that point, right? Now, we could obviously offer a new resolution. We could keep this resolution in place and work on negotiating or changing some of the language in the cooperative endeavor agreement to incorporate a greater sphere than just the Marie and Charles Memorial Park. Okay. So not only Sam's question of, hey, does it end the whole litigation question, is there still opportunity to amend either one of those two documents? Does that open us up to more problems or less problems from a legal standpoint?
Well, you still have a lawsuit that is filed and pending the submission of everyone's briefs to the Second Circuit. So the question is, does any part of what you just suggested resolve the lawsuit, or does any part of what you just suggested allow the Dog Park Alliance and Ms. Keith, who's a plaintiff in that matter, to consider dismissing their lawsuit? And none of that is going to be determined until there is discussion among the parties as to what will it take, if anything, to resolve the litigation.
Gotcha. Okay. That certainly
Well,
sounds to me-
can you send us something on it? Can you send something confidentially to the council on the question that's being tendered here about the effect of
I can do that.
212? Yeah,
I can do that.
that's something I need to know.
The other question is it any way between now and tomorrow that you might be able to contact the attorney for the Dog Park Alliance?
You might be able to.
He's here, Mr. Shine, so I think he's
Right.
hearing what you're saying.
Oh, okay. Well, that's good then, if he's hearing all of this discussion. Would it be proper at this time if we could maybe not necessarily get an opinion, but maybe if you could speak a few words on that?
How appropriate is that with
The
pending
legal.
litigation?
Let me speak to this. I know, because I see how she's staring at me, that the city attorney wants to, as she mentioned, this is litigation. But from my perspective as mayor, and more importantly as a citizen, there's nothing about this that needs to continue to be done behind closed doors. Nothing.
Well,
Bottom line,
well,
if you let me finish.
Okay.
We started and planted a poison vine on this whole situation the day that Tim Watchell responded to Randy Lucky's email with the caveat that this $280,000 I just listed to you does not represent the cost of constructing a dog park. But we have attempted to build, or parties have attempted to build a case and a position for a dog park starting at that point going forward. We believe that we have effectively established that particular scenario does not need to either go forward anymore or cost the city of Shreveport any more money. What has now been proposed is that we look at pursuing a scenario that entails the Stoner area. In order for that to happen, we still need to resolve the issue of 133. There's only one of two ways in which that can happen. The most definitive way is for the dog park folks to dismiss their lawsuit. From my perspective, I think that the council and the city of Shreveport needs to be responsible for acting as well, if or in place of, by simply rescinding the actions taken with regard to the passage of 133. So with that, didn't know that Mr. Keel was here. Mr. Shine, I welcome him to come up and engage in dialogue. And from my perspective, it all needs to happen so that these cameras and all these folks and everybody who has sought to spun and spin and twist this thing over the last year plus can see what's actually transpiring here.
I think the mayor has answered my question, and if it's all right with the council members, and if the attorney does not mind, I see him saying yes.
And let Terry say for the record what she needs to put in the record so that it's clearly established what her position is. But please, let's proceed.
I think
But
she
she's
just said
already
it.
said
I
that.
think she just
She's
said it,
already
right.
said it.
Right.
Yeah.
I apologize for my appearance. I was having a work session down the street.
That's okay. You look like us.
But I have my cerebral and ceremonial dog park shirt
Oh,
on.
okay.
So I guess I'm equipped to answer the questions. I offered it to the mayor, but
They didn't make those in large mammal sizes. I tried to get one.
we had to fight over it for a little bit. What I wanted to say is that I have had discussions with the attorneys that are retained. It certainly isn't the desire of the Dog Park Alliance to continue the appeal. In fact, we don't actually have control over the appeal. The appeal is owned by the mayor, and one alternative he hasn't suggested, and I don't blame him for not wanting to do it, but one option is to abandon the appeal. But that puts the trust on us in a different situation where he's got to trust us not to proceed further. I am open to communication I am open with welcome arms to try to work this matter out. That's why I made the overture to suggest that we should consider Stoner. I didn't tie the resolution to consider Stoner with the dismissal of the lawsuit or with this resolution. I didn't get an email from the city attorney for whatever reason. My communications have been from me that way, and I haven't been getting much back, which I understand that as well. But we're certainly, what we want basically is, let's find a way to have a bird in the hand that works for everybody, works for the citizens of Shreveport. And if that means that the attorneys and I need to find a way to delay, I'm all open to that if we can find a way. But I think that taking the complete abandonment and taking this action totally negates the lawsuit and doesn't resolve the issue that we spent $35,000 or $40,000 of government money on. So, I mean, if we can solve the dog park issue, it's a separate issue, and we're willing to adjust and fall back and be very open, because, you know, this is a matter that we want what's best for the city of Shreveport as well. So whatever I can do, I will do, even though it's we're at 2-minute warning and we're down at the end of the wire. The December 23rd date is my response deadline. I'm willing to work with the attorneys on delaying it. If we can seek a joint motion to postpone it for a while, whatever vehicles are available, we're willing to do. That answers your question, Mr. Shine.
That, it does, because I see the lawsuit dealing with more than just the dog park. I see the lawsuit, and I could be wrong, but I see the lawsuit too, kind of from the kind of standpoint on whether the mayor has the legal power to do what he's doing, or whether the city council had the legal authority to pass that ordinance in the beginning. And you know, to me, this could be a discussion that doesn't necessarily have to do with the dog park. That could do with any situation that would come up that would have the same scenarios involved in it. It's not just the dog park, so to speak. So, you know, this is why I kind of want to know what was the feeling of the dog park people.
We separate them in our mind as well.
Right.
And I wasn't actually speaking in a way that settlement negotiations are so much the point that we reach that point, because we have to have conversations, we have to have some promises, and I'm sure that Ms. Keith is very amenable to alternatives. I've discussed with her the Stoner agreement, and I've discussed with her possibilities and other board members. We were trying to find a way to apply, have an entity apply for Stoner. We couldn't find it on the web. So, you know, we still got a few little humps to work out, and those things can be worked out. I'm intrigued by Councilman Oliver Jenkins' suggestions, some other things that can happen. I think there's some gradations that we can reach, and we are certainly willing to make this our top priority. I will make it my top priority to try to resolve it. And I want to work with the mayor, and I spoke with him after the Texas Avenue Makers Fair. And, you know, we understand he has a position, and we have a position, and whatever we can do to work all those things out. But they are, to me, what I would say bifurcated. Right. They may collide if we totally dismiss it, and I would handle some matters if I were the attorney of this. But this isn't something, and I just want to make clear for the record, we didn't ask for this repeal of the resolution. Right. This is not our baby. No. It's not our idea. So just as long as that's clear.
Mr. Chairman, it's back in your hands.
Thank you, Dan.
Thank you.
Any other questions?
And Dan, you may want to stay, just in case you want to comment on any of that. Mr. Shine is exactly correct. This issue is important beyond just the dog park. But the situation and circumstances clearly illustrate exactly why it is that anyone who sits as mayor of the city of Shreveport should take the position that this administration has taken. Had we not done so, had we followed exactly where it is that this process was leading us towards, we would now find ourselves in a situation where the taxpayers of the city of Shreveport would be on the hook for hundreds of thousands of dollars, contrary to what was being represented to this council. and what this council has gone on record as having said that it did not want to see. This council, September of 2011, clearly established that wrought iron fencing is the design standard for the Clyde Fant Parkway. That question was specifically asked of me to you all prior to the vote on the resolution establishing dog parks for the city of Shreveport. Clearly. Mr. Shine specifically talked about how his constituents would not take kindly to the notion and idea of public dollars being spent for such a fanciful notion. It was without the support, without the feedback of either this council or the administration that parties outside the city of Shreveport went before another governmental entity and requested funding for the establishment of a project that would have to ultimately be overseen, managed, and be responsible for by the city of Shreveport. The information utilized to request that funding was inaccurate. And that was clearly stated to the individuals who were requesting it. And despite the fact that all of those things were pointed out, expressed, and objected to, this action still moved forward up into and including not only the drafting of a resolution, but the drafting of a resolution that was unprecedented in the 35-year history of this form of government for a resolution to be composed in. No other time has there been an authorization that requires a specific contractual agreement with the degree of specificity that this one includes, which names the location, which specifies the level of expense that the one party is engaged in, that clearly makes it clear that they will not be responsible for anything else beyond that anything else above and beyond that will come from the city of Shreveport. The reason why you don't do that, Mr. Shine, is so you don't find yourself in a situation where you have to come back and explain to citizens in other areas that have other needs that we're not going to do certain things in your area because we now have to redirect these dollars to fulfill our contractual obligation to construct the dog park under these circumstances. And so it's absolutely imperative that no administration find itself in a position where 5 members of the council can compel it to do something that is against the best interest of the city of Shreveport.
They just changed it around. They just took another person.
Conversely, there is nothing that any mayor should be able to compel this council to do that is against the best interest of the city of Shreveport. That's called a check and balance.
I don't know.
What's the savings in that?
What this action entails is above and beyond that. What it has entailed is the ignoring of what have been clearly established facts
And so they've eliminated.
that we have shared again and again. We had meetings in here. We had meetings up on the second floor. We had meetings back in June of this year where members of this council said, if I'd known these things, I would have done something different. We've got citizens who have sued us, which entails the need to retain professional counsel, not to carry on the politics of this thing, but to protect the interests of the city of Shreveport. And that's what we're trying to do. We're trying to resolve it here today so that we don't have to keep paying lawyers to protect the interests of the city of Shreveport. That's what we're here to do. Resolution 133 of 2012 is not in the best interest of the city of Shreveport. Now, the folks who are filing a law, who have filed the lawsuits on the basis of that, either need to dismiss it or this council needs to nullify it. While we're doing that, we also can continue, as I have expressed and committed to engaging in the discussion of the alternative location, as well as what should be a conversation about other locations around the city as well. But if this is where the party that's involved didn't like, they liked Hamels, but cannot refute the information that we've shared. Councilman Oliver Jenkins says that he thinks so, but has not come up with anything to present to either council members, the administration, or anyone else about how you effectively and in good conscience build a responsible dog park at Hamels for $280,000. So we can't deal with that conjecture until it takes some kind of actual form and detail.
Well, he did mention that a fence could be constructed for that amount of money. I mean,
Has to be what, Jeff?
a fence could be constructed for that amount of money. The fencing that is part of the build-out of the park is around $280,000.
235.
235, so under.
As I said, responsibly.
Well, there are many dog parks that just are just a fence. I mean, across the country.
Our duties and responsibilities are to establish a project. Not to make it a Taj Mahal, not to make it the world class, but to do it in a way that ends up meeting the basic requirements of what it is that we're going to say it's going to be. If we don't do that, then what happens is once it opens, folks show up down here and say, why did you guys build such a crappy thing? You didn't include this, there's no place to park, it's not ADA accessible, you don't have any water, this, that, and the other. So that's why you advise staff, based upon what are considered to be appropriate best practices, how do we establish this project? So tell me how we responsibly and appropriately do it. Nobody's done that except to say we could build a fence.
And then we're expected to maintain it, right?
Correct.
And a few other
That's what's projected to be $100,000+ a year.
Let me,
So is it in order to move to add this to the agenda, Resolution 212?
this is work session. We're not gonna do it
Tomorrow.
Tomorrow.
Let me offer this.
Move forward to be added.
At the first or second meeting that I was chair, one of the topics we talked about, and one of the things I asked for, is that we resolve the dog park issue, which was already an issue at that point, that we resolve it quickly. Here I am at my next to last meeting as chairman, and we're no further along than where we were a year ago. I think the last few minutes of exchange highlights exactly why we aren't moving forward. Is we haven't had enough open discussion, we haven't had a true planning meeting, we haven't had the share of ideas about what are we looking for, what's the design everybody can be on board with, what are the basic necessities, what's one step up, what's two steps up, what gets us to the dog mahal. I mean, that open conversation, although it's happened, I guess, in small groups, it hasn't happened with council and administration and the Dog Park Alliance all at a table recently. Now, whether we pass Resolution 212 and we do away with Resolution 133 of 2012 and we start the process over, I mean, that's a decision that we make tomorrow as a council. If we don't do that, we've got Plan B or Plan C out there. What I don't want to happen is that we continue not making progress, or we pass 212 and we don't move forward with the conversations and including, making progress. I mean, it's at what point are we going to make some progress and make a design? And Mayor Glover, I'll ask this, recognizing that the information's probably outdated to some extent by now, but if there's anything about the Stoner site that could be shared with the council via email or a brief presentation tomorrow, just to refresh us about that site, that would certainly be appreciated. Because as I understand it, what we'll have to do, what we would, as a council would have to do, is if we wanted to consider Stoner, we have to, I think, coordinate with the parish and get Stoner approved as a site for a dog park, and then we pass legislation for that. And then everything else would move forward from there. But, I mean, folks, we got to do something to move the ball forward. Councilman Webb.
Yeah, Mr. Chairman, and Mr. Mayor, if you're going to do that, I mean, I know we met last week upstairs, you mentioned the two parks that we have in the city of Shreveport, and there was no discussion as to comparison money-wise if we do the joint venture at Stoners versus if we go solo, the two city parks in the city of Shreveport. I'd like to really know what we should be looking at money-wise in comparison to just having one and it being downtown on the riverfront, even using the 280.
Okay. Will do.
Okay.
Shelley, you get that? He wants us to, one of the things that we've also talked with council about, Mr. Chairman, one of the things that we've also talked to council members about is the, in relation to Resolution 212, which references the nullification of Resolution 133 and also directs staff to offer recommendations on the establishment of dog park / off-lease areas within existing park areas. We talked specifically about Betty Virginia, Southern Hills, Bill Cockrell as being the kinds of locations that would logically lend itself to those types of things. What Councilman Webb, I think, wants is to hear what we would project the expense, the cost to be of those non-river Clyde Fant Parkway locations in comparison to the Stoner location. And part of Mr. Webb, I think I mentioned to you, was that we saw the other park locations, be it Princess Park, Stoner Hill, I'm sorry, not Stoner Hill, Princess Park, Southern Hills, or Cockrell, or Betty Virginia, as what have you, as being the kinds of scenarios that would follow along the way that Baton Rouge has done, where they've gotten the outside corporate sponsorship that has essentially covered much of the capital expense of those projects. Cost-wise, they end up being simpler because you end up making use of some existing fence line within the existing park. You end up being able to put a logo and signage on it that allows it to be branded, and you've got some corporations out there that have written some rather sizable checks to help make that happen. Those are alternatives that we see for all of those other places that would be off of the Clyde Fant Parkway. And that one of the limitations of Clyde Fant Parkway is that because there's no signage allowed, you wouldn't be able to get that same sort of benefit because there's an ordinance that prevents any sort of signage on the parkway.
Though I'm not
Let me
sure
say
those
this. Let me
advertisers
just-
are as interested in advertising a location that's not supported by the people who are advocating for the park. So, I mean, I do think it would be, if I was an advertiser, I would want to know, does the Dog Park Alliance support these locations?
But we've not formally had any of those conversations, Jeff, so that wouldn't be.
If I was an advertiser.
But again, we've not had those any formal conversations, so it wouldn't be accurate to represent that as being anything other than just your opinion.
No, I'm just saying, if I was an advertiser, I would find it a difficult proposition to advertise someplace that was opposed by the people I'm appealing to.
Let me just comment on what the chairman said. Mr. Chairman, I think he really made a good point. We have discussed this, and I was hoping, because traditionally the policy is that the vice chairman would become the next chairman, and I would hope that I would not have to discuss this as chairman. And I was hoping that you would be able to bring a resolution to this discussion, and I was hoping that that would be one thing that you would have been able to accomplish, and you could have said, well, I was able to accomplish this as chairman to get the dog park settled. But it seems like it's just going to go on and on and on, and you're exactly right. I was hoping that we could get this settled during your administration. So even tomorrow, I would hope that we would be able to come up with some kind of resolution to this, because it's just going to keep on and on and on, and I would hope that we would take a look at this and see if we can come up with a compromise.
I wanted to make sure you had plenty to do.
Oh.
Any other discussion? Thank you all. All right, I believe the only public comments I have are related to different appeals on our agenda, and would like to suspend the rules at this time and take up the ADO appeal.
Yes, thank you, Mr. Chairman. If we could, I'd like to suspend the rules and bring up the Raceway
I'll second that.
ADO appeal. Hopefully, Carver Collins.
Did you make the motion?
Yes, it is.
I second.
Yeah,
We need to vote on it.
Motion by Councilman Sam Jenkins, second by the Vice Chair.
It's Carver Collins, whoever's going to handle this
Webb.
matter here.
Unfortunately, you're here at a meeting so that we can actually take care
I
of it.
don't know if it was a part of Councilman Sam Jenkins' strategy, but at now 4:30, I know these lawyers have been here on the clock since at least 3 o'clock, so we've just helped them.
He's looking out for y'all.
We've just helped them with a couple of Christmas presents on these 2
We were having that
hours.
discussion up here. You can hear this loud ticking sound.
I think everyone's brain went to the same thought.
Every time you said fire the lawyers, all those guys on those start looking at you.
Okay.
Carver Collins, I believe, appreciate you being here. I believe myself and Councilman Everson had an opportunity to discuss this a little bit off the record with you. And so what we want to do is kind of go on the record and hopefully make a decision about this Raceway appeal.
All right.
All right, so
You've turned to tab 1 in your books there. It's alcohol permit appeal for a renewal of Raceway 6802, which is 3701 Hearn. Basically, what they had is 2 violations with guilty verdicts. The first violation was underage sales. Actually happened on 3/13/2013. The applicant or the employee pled guilty on 4/30/2013, and on 6/5, another one had underage sales, pled guilty on 9/10/2013. I included 2 other ones in there, were pending at the time. One on 6/28/2013, Noibio card. At the time, pled not guilty, there's a trial. And another one, 8/1/2013, underage sales, and that was pending arraignment when I first denied it. The update on there is the first one did not make it to court. She's currently got a warrant for her arrest. Wow. And there's next one, the last one has a continued arraignment for 1/28/2014. So there's the last 2 there. We have nothing on them. So basically, they've been denied due to the 2 violations they had, which both of them pled guilty.
And have there been any subsequent violations since then?
There has been one, I believe it was on November 1st, there was underage sales.
Kind of every 2 months.
Excuse me?
That's what I was looking at.
Looks like about every 2 months. And so I know that in our discussion earlier, one of the things we were wanting to do was address the situation but keep with precedent in the past. What is some comparable action that we've taken for somebody with this number of violations in the past?
In the past, one of the things you have done is probation. With a low number of violations, a lot of time you have decided to go with probation. There's been one time, actually it was in Mr. Shine's district quite a while ago, where one was actually denied and upheld. And there's times when you've taken no action, you just basically overturned. So it's really up to you based on the violations. Of course, the police department's asking for uphold of denial, but this is not one of the bad cases we brought it before you. They just don't meet the qualifications, so that's why we brought it to you with the 2 violations.
Well, and I don't mean to talk over you. I know we've
No,
had similar conversations.
Go right ahead.
I think we were starting at
Go
the
right
same
ahead.
time. I will say to the council, this is a location that there's some concern about. Obviously, there's been some incidents here that are cause for concern to public safety. We have been in communication with some of the parties, both the applicant and the corporate partner that owns the raceway. Have been in contact with the police department to discuss ways to have additional security there, to modify their security plan, to do things that will keep it, that will improve the public safety at this site. I can't speak for everyone, but I think that a probationary period is something that that would be helpful and move the situation along in implementing some of these public safety. We can allow that. Yeah, we can
If they
allow,
wanted to.
we can allow there's representation for both of those parties here today. I think we can invite them up. Certainly, I didn't mean to.
If they desire to say anything, but I can support a 6-month probationary period in this case, to uphold the denial and place them on, can you do it that way, then place them on probation for 6 months?
Usually if you do it that way, you'll overturn denial and put them on a 6-month
Okay.
probation. I think that's the way it's been done in the past, but whatever your wish. I mean, you can do it either way.
No.
Sam, before you do that, Mr. Chairman, I'm not against what you're saying, but Corporal Collins, if I'm not mistaken, didn't we have a problem there a few years ago?
Why don't we just wait?
I can say it was not a problem relating to alcohol issues. I can say that.
Okay. You know, I just wanted to make this statement to the owners, I guess. You all make sure you be on your A game from now on. Whoever you put there that will manage your business from day to day. Because it seems like about 3 or 4 years ago, Mr. Sibley, I don't know if just pinpoint what it was, but you all came before the council, and this is before this council was seated. Ron, I don't know whether you remember, but the raceway is right across from my district. I think it backs up to
mine and
right. It backs up to the two of you all, but it's right. It's right in front of my district, and I don't want to do anything. I'm pro-business. I don't want to do anything that's going to hurt your business. But from now on, please make sure you're on your A game. Make sure whoever you have working your business, that they understand that what they are doing is not only jeopardizing their job, but they are putting your business at a disadvantage. And you might have to have somebody to remind them of that from time to time. You know, I would say in the beginning, maybe every 3 months or so, because a lot of times people do this, don't mean any harm, but they break the law. And it puts us in a bad position, because then, believe it or not now, we will have the situation that will come that will impact another business. And we try to be fair. So if you all could keep from putting us in that position, just to let your employees know, now look, these are some things that you just can't do. Underage sales, you just can't do that. No matter how big a hurry you're in, but if you're selling a product where you might even think that there might be a legality involved in it, don't do it until you check it out. I just wanted to make that clear.
These employees, they're no longer with the store, I would assume, right? Okay, all right.
And I do have 2 requests to speak if we want to allow that right now.
I was going to ask if there were anybody in the public that wanted to speak. Another question I had was if they have the card readers that we sometimes ask to install.
I'll let them answer those type of questions.
Philip Downer and Jacob Oakley.
Well, and Mr. John Harris,
Hold the
you
mic.
have to ask, and if you want to let him go first, that's fine.
Okay.
That's
Yeah,
fine.
yeah. If you would please state your name and address for the record.
Sure. John Harris, 9335 Ellaby Road. I am attorney for the licensee. We have tried to address a lot of these issues before, and we've been before the council before with other clients that have similar problems. You know, we try to make sure that those card readers are put in place as soon as there's any kind of issue or concern. I think it's a best practice for these kind of businesses and locations. Additionally, you know, we've done additional training with the employees so that they understand the seriousness of it. As you guys involved in business understand, you know, it's hard to find employees at the wage that you have to pay to have these types of employees buy into the seriousness of what's going on. And so we've implemented new training involved so that they're getting routinely, kind of always in their ear, the kind of stuff that needs to be happening, the steps that need to be taken. The card readers are mandatory. Every time there's a beer sale, that has to be swiped. And so we've made sure those are in place
now?
They are in place now. They occurred since the last sale occurred.
Okay.
So, you know, I don't think that the licensee was aware of those systems that were available, and they put them in place since then. So I'm happy to answer any questions. They are taking it very seriously and very concerned about it. But every time, you know, obviously the policy has to be that every time one of those employees has an underage sale, they're terminated on the spot. You know, in the past, some employees cared about being terminated, and I think in this economy, everybody wants a job, but apparently these people were willing to take the risk and didn't take it as serious as they needed to.
Well, I have, you know, we've had discussions before, as well as the other attorneys and past owners there at the store, and I've always expressed my concern about what's happening in and around that store.
Absolutely.
And, but I do believe, if I'm hearing right, there's going to be some changes being made, change in approach,
Absolutely.
changes in the ownership and the management there in the store. And I'm certainly hope that, you know, whoever comes in and kind of take that store over, you know, one of the first things they may want to do is reach out to some of the neighborhood leaders over there and begin to work with the neighborhood. Let the neighborhood leaders know who they are and see if there's ways for them to work together, because for whatever reason it is, it just seems to be a lot that gets started around that site, and it finds its way off into the community.
Right.
That's what gets everybody into an uproar.
Right.
But, you know, I'm willing to support the idea of some kind of probation here in light of the fact that I see some things may be done differently, and that the safety of the community is going to be a concern. And my suggestion is going to be reach out. You got some people that are working very hard in that area to bring that community back around. Reach out to those people, talk to them, let them know who you are, and become familiar with one another and work together to deal with what appears to be some of the bad things that continue to come up at that location.
Absolutely.
And could you remind me, where is the security in place now and from what hours?
It's done on an as-needed basis now. I mean, you know, I think a lot of the concerns that the council's mentioning now are the cruising concerns, excessive loitering. You know, when you have a business that's, you know, trying to make ends meet, you know, having security there full-time has been a struggle for them, because paying that off-duty police officer is going to be 3 or 4 times the cost of having an employee there. And so they try to, you know, obviously keep as many people employed as possible, but that cost gets to be prohibitive to have at a full-time, you know, all the time kind of basis. So, you know, as they have peak hours, as they have those problems arise, they try to get the off-duty police officers in there as soon as possible, but it can be unpredictable. And, you know, if something happens on a Tuesday night that just nobody expected, then, you know, it's kind of one of those things that happens maybe to any business to be engaged in this type of activity of selling gas and being a kind of meetup place, especially in a neighborhood like we're talking about here. People are very social, I think.
He had, at one time, almost a 24-hour security there, but the Court of Appeals told us we couldn't do that.
And it's tricky. Yeah, it's very tricky to have.
Yeah, couldn't require it. But it was, and I'm just trying to go off memory here. I know in some discussion, I thought I recalled that there was a security guard on duty from 11 o'clock at night or 10 o'clock at night until 3 a.m. or something.
We do have security in place Friday, Saturday, Sunday right now. Especially as we have kind of that peak time. I would suspect during the winter season that some of this cruising and loitering may slow down some. So it hasn't policy that's, you know, set in stone. We don't want to mislead the council to say that it's every Friday, Saturday, Sunday, but it is, as, you know, the peak seasons where this type of activity occurs, we do try to have off-duty police officers there.
Well, hopefully the new ownership, new management that's going to come in place would take the suggestions of those of us up here who have expressed something. And hopefully we won't see the raceway coming back and being an issue before the council or in the neighborhood.
Absolutely.
Anyone else who'd like to speak?
I want to ask one question, and whoever, and it may be more appropriate for you to answer this one. When is this change of ownership taking place or proposed?
Right. Let me introduce myself first. It's Philip Downer. My address is 401 Market Street, Suite 1250, Shreveport, Louisiana. Right now, we're in contract negotiations or issues with the current operator. We're working that through right now. We expect something to be done within, 90 days or so is what we're looking at. And that would have been running from early November. Now just to answer you directly, that's what we're working with. But those are private contractual matters, which of course, I don't know that you necessarily would be involved with, but that's certainly what you're asking me. One thing I did want to point out to you, Mr. Peter Brust is with us today. He's the district manager for North Louisiana. We've also had meetings with the police department, with city attorney. I think we've expressed and opened some dialogue. I also want to point out to the council that, look, you're welcome to call me, or you're welcome to contact Raceway directly. You can contact them through their website, however you choose to do it. But if you have an issue, let us know. I mean, one thing we want to make sure is that we do know of any sort of issues that are coming up. And sometimes they get directed maybe just to an applicant or just to an employee, and we don't find out about it. So anything that you have an issue, just be sure and let us know that. And I am happy to answer any other questions that you might have.
I just have, I guess so what impediment does it present to this contract negotiation if we don't allow the current management ownership this provision and let it be effective as of that change of ownership?
It has detrimental impacts. The store certainly has to operate during the continuing period, and then also it would be an impediment for the new operator coming in or anybody else that came in. It would cause issues with respect to different matters that pen before the city, not necessarily the liquor license. And so we believe that the applicant probably, and like I say, you're within your discretion to put the probationary period on. I think that's more than fair. And the other thing I would say is that the racetrack itself is going to have somebody come by the store and check on the store certainly more often during the transition period.
Any other questions? Anybody have additional questions, or does everybody kind of
When does the
understand?
transition period take place?
It's in the process of taking place right now.
And what we're looking at, a month, 2 weeks, what?
It's roughly, it should be around a 90-day period, so starting November, early November. So you're looking at, roughly toward the end of the year, first of next year.
So right now we have a motion to overturn and place on 6-month probation. Any violations that come back before the council.
After the change of command?
Start immediately. If any violations take place during the probationary period, bring it back before the council.
Okay, and my one question for Corporal Collins is, naturally this issue in November, isn't that going to already trip this?
No, because if you make it effective today, then that the violation's already taken place.
Okay.
I mean, that's up to you how you want to word it, but that violation's already taken place.
Mr. Johnson.
I wasn't here, and this might have been answered, but is the license issued for 1 year, but if there's a violation within the next 6 months, and it automatically comes back? Or is the license just for 6 months?
I don't think that we discussed that.
The way you've done it in the past is the license is good for a year. It's a 6-month probation.
The general license.
And then basically what happens is if there's a violation, then we'll bring it back to you immediately, and you can take any action you deem appropriate at that time.
I just wanted to be sure.
Whether it's suspension, revocation, denial, whatever it is.
Yeah.
Which we'll probably bring back on this denial.
If they have a violation during that 6 months and they come back before us and we withdraw their license, how long do they have to wait before they can reapply?
That, on a denial, if they're denied, if they have the violations are good for 2 years, basically. So if they have 2 violations in 2 years, then they have to wait till after that 2-year period for that operator. And just, if this transition does take place, or we have a new operator coming in, all this stuff is kind of out. That any restrictions you put on this operator will not pass on to the next operator, because this license is under appeal, not the new one. When the new one comes in, it's clean slate.
And we're hoping that's what the goal of all this is going to be. That's why we try to make sure it's a long enough probationary period for that ownership to transpire or change hands.
You made the motion that Jeff seconded? 6 months?
Either that way or the other way, one of the two.
Based on
Which way? I mean,
I don't remember, honestly.
Right.
Motion by
Whichever
Councilman
way.
Sam Jenkins, second by Councilman Everson.
All right.
Please vote. And that is 6 yes, 1 no. I believe that's the end of our ABO appeals.
it is.
Mr. Chairman, it's, while we still have the rules suspended, I was trying to see if, the zoning case here, Floyd Edward Williams.
He's
I don't know.
not here.
He's not here?
You can't
What's-
take that up today.
Yeah, so we have to do that tomorrow.
You have to do that one tomorrow? Okay, all right, okay.
But I gave you that information
All right.
because you know your concern was you wanted to look at those dates.
Okay.
And so that's why I provided you that.
All right, well, thank you. Okay. Thank you, Mr. Chairman.
Mr. Chairman,
Yes, sir.
while y'all are in the suspended state, would the council consider allowing us to go ahead and do the property standards appeals? Our director is getting a little under the weather, and she'd like to go ahead and possibly be able to.
Don't step right on up here.
If she's
Come on
got
down.
the fortitude to
She's
get
been
through it.
hanging. She's been hanging, and I'm sure she would hang, but she didn't even know I was going to ask y'all to do that. But
Mr. Sibley, I would hope that she would probably bring a handkerchief or a napkin or something, so.
yeah, we don't want to catch it.
Yeah, we don't want to catch anything.
Stay right there.
Mr. Chairman, maybe
Don't
Mr.
catch anything.
Sibley can tell us what under the weather means later.
Thank you, Mr. Chairman.
All right, Dorothy, case number 1.
Thank you very much. Our first case is 1447 Andrews Street. It is in Ms. McCullough's area, and the owner has demolished the case, so we are going to close that one.
Second?
I'm sorry, which one was
Oh, I
that?
don't, do we have to vote on closing?
1447 Andrew.
Yeah.
Do we have a motion? Do
Councilwoman.
we need a motion?
Has been demolished. It is
That's
up for
fine.
demolition.
But I talked to Don Ellis, so I knew it had been demolished, so.
Motion by Councilwoman McCullough.
Sometimes you have to
To
believe in your
close the case?
constituency.
To dismiss the appeal, I guess.
To dismiss the appeal.
Dismiss
Second by
the appeal.
Councilman Sam Jenkins. Please vote.
Mr.
Well
Toler?
done.
Oh, you waiting on us?
And that is 7 yes. Case number 2.
Our next case is 3015 Catherine Street. The owner is present, it's under, in Councilman Jenkins, Sam Jenkins' area. And he only needs 30 days to complete the outside of the house.
How do you feel
And
about that,
I have
Mr.
no objections to it if you don't.
All right, so move
Second.
40 days.
Motion by Councilman Sam Jenkins, second by the Vice Chair for 30 days.
But you said was it 40?
30.
30 days?
30 days.
30 days, I'm sorry, 30 days.
So he good.
You want December the 20th? That's when our council meeting is, or do you want to make it in January?
January 14th. Will it? 13th.
It's either December the 20th or January the 14th, 13th.
13th, let's do it January 13th.
So move.
Second.
Please vote.
Maximize
7
the
yes.
opportunity for success.
Little holiday gratitude there. All right, Dorothy, case number 3.
Case number 3 is 360 East 68th Street. The owner is present. This is under Councilman Oliver Jenkins' area. He's here. This is a demolition. He wishes to demolish the house himself. He's asking for 30 days to clean the house out and another 60 days to demolish it. And that's been depending on the weather also. I want to put that in there. But I have no objections. He is here, Mr. Maurice.
Okay, so you don't think that's an unreasonable amount of, that seems like a lot of time for me, but if you, and obviously I defer to the person with the expertise.
I don't, because of this is a large house, It is filled with furniture and things, and he's trying to get that moved out and doing some cleanup around it, and another 60 days for the demolition, only because of the weather and everything, so that's the reason why I'm allowing it.
Okay.
Not demolishing the backhoe.
If you would come up to the microphone, please.
This is Mr. Maurice.
Will not be demolishing the backhoe
To the microphone up here.
I will not be demolishing with a backhoe or a dump truck. This will be by hand. I do not have the money to do it that way. I have had some financial reverses. My wife just died. I don't have the money to go that route. So I intend to use the services of a son, and I intend to do this by hand. So that's how it's going to happen.
Okay, so moved for 90 days.
Second.
Motion by Councilman Oliver Jenkins, second by the Vice Chair. No further discussion, please vote. That is 7, yes.
What day is that?
Tell him that
before he leaves.
January 13th, I thought it was there.
It's the next meeting.
That's
27th, January 27th.
No, 90
No, could be. Could be.
90
90
days?
days.
It's got to be,
Yeah.
Did he say 30 plus 90?
30 plus 60, it's going to be a total of 90 days.
Right.
First meeting in March.
actually, it'd be the last
February,
meeting in
March.
February.
March
Should be the last meeting in February, but I'm happy to go with.
March the 10th.
I can tell you that's not 90 days, but I'm okay with March the 10th.
It's your motion, Mr. Jenkins.
I'd like 90 days, so that should be the last meeting in February, I'm assuming, because we are in the last meeting in November.
That'll be the 24th
24th.
of February.
Is that a holiday that weekend?
February the 24th.
February 20th.
Who seconded the motion?
I did.
Thank you.
Thank
All right,
you.
Ms. Farnell, case number 4.
Our next case is 1447 Hollywood Avenue. It's in Councilman Shine's area. Unsure if she is present. This is a demolition. She has been rehabbing the house. As you can see, she's done a considerable amount of work, but there's still a lot more to be done. Have not had a chance to talk to her, so I'm unsure how long it's going to take for her to complete.
Well, from what we were ordered to do.
Would you step up to the microphone and state your name,
From what we
please?
were ordered to do, we have just about completed that, but went back to do the house in the original stage. It was a long porch with a screen porch, so we decided to make that screen porch another room. So that's what's delaying the process. So if we could get about 45 days, 30 days to 45 days, we will be complete with the whole thing. And we're working on the roof also. We were not ordered to do that, but after we started working on that, we found out that we had some leakage, and we are working on that too. So there have been several problems that we have come into contact with since we have been working on the house, and we are diligently working on the house. 45 would be fine. I believe with 45 days would be okay. That's my son, he's in charge of that, 45 days.
What about January the 14th?
13.
You asked for 45.
45, yes.
Let's give her 50, let's give her 60 days since holidays coming up. Had a good Christian over here who's.
I'm all for that.
Motion by the Vice Chair, second by Councilman Sam Jenkins.
Yeah. Yeah, had a good Christian over here who said the holidays are coming up.
Yep, her name for the record.
You need to say your name for the record.
Okay, my name is Mary Taylor Dickens. Mary Taylor, Dickens.
Thank you, Ms. Dickens. And I happened to drive by that house today, and when I opened up our book and looked at pictures up here, I thought, I've seen that house, and I realized, and I'm looking forward to you getting finished with it, because that's going to greatly improve that little stretch of Hollywood.
Okay, thank you.
I drive by quite often, and Mr. Harris, that's kind of that little stretch in there where it's just, you know, where we got that asphalt overlay. It's just terrible. So, I mean, see if you can get somebody out there to look at it, and that's some of the asphalt that, please. Thank you, sir. Thank you, Mr. Dickens, and I just want to wish you some happy holidays here, Thanksgiving and Christmas. All right.
Arthur, do we have 360 68th Street?
Wait a minute.
360 East 68th Street?
Yeah, that's the February 24th.
That's the one that we have for February the
February
24th, for 90 days.
I think the address, there's a difference in the
Yeah,
address
we've
on the
done it all.
agenda and the actual address.
Thank you, Mr. Chairman, for allowing us to take those on board.
Thank you, Dorothy. Feel better.
Dorothy, get some rest.
Chicken soup.
We'll now return to our regularly scheduled program, and Mr. Sibley, if you're still awake,
I'm saying.
I ran out of coffee, Mr.
let's
Chairman.
proceed with the regular agenda legislation.
Section 9, regular agenda legislation, sub-A, resolutions on second reading and final passage, or which will require only one reading. Number 201, authorizes the mayor to sign an engagement letter and agreement between the City of Shreveport and BKD LLP for an external audit of the City of Shreveport for fiscal year January 1, 2013 through December 31, 2013. Number 202, approves the 2014 Downtown Development Authority Program of Work. Number 203, ratifies the use of certain equipment and Festival Plaza by Sports Spectrum Race Management. Number 205, authorizes the execution of a collective bargaining agreement with Louisiana Public Employees Council number 17, American Federation of State, County, and Municipal Employees Local number 13-25. Resolution 206, authorizes the mayor to execute a contract agreement between the City of Shreveport and Denny Drive Water System, doing business as Eagle Water Incorporated, for emergency connection water supply service. Mr. Chairman, members of the council, we're going to ask that that matter be postponed. We're waiting some additional information from the applicant. Number 208 states the City of Shreveport's endorsement of Home Federal Bank to participate in the benefits of the Louisiana Restoration Tax Abatement Program and to otherwise provide with respect thereto. This matter is subject to a public hearing to be held on tomorrow. Number 210 declares the city's interest in certain adjudicated property as surplus. And number 211 authorizes the finance director to create certain journal entries relative to the closing of the Information Technology Internal Service Fund.
Any discussion?
Did we do 204?
No.
Probably
Yes.
because it's already happened, but that's all right.
Oh, wow. Yeah, I did 203. 204, excuse me, Mr. Chairman, also ratifies the use of certain equipment and Festival Plaza by Sports Spectrum Race Management. Let me go back. I don't think I did 203, which authorizes the use of certain equipment by Sports Spectrum Race Management.
Councilman Everson.
I was just going to ask, in regards to the piece of legislation that the administration mentioned would be added tomorrow, it sounded like it may have some impact on Resolution 202, but I just wanted to ask and see, is that like an amendment to that, or?
And I'll defer to Julie, but I appreciate it. We need to do, for budgetary purposes, approve their 2013 program of work for the current year, and approve their specific program of work with the dollar amounts and everything for 2014. I think they're related, but not necessarily the same as the one that's on here today. And Julie, if you could help out, I'd appreciate
They're
that.
actually budget ordinances. B noticed that we had not properly done the 2013 budget ordinance, so this would be adoption of that budget ordinance plus adding the 2014 budget ordinance, for the year
For the
2014.
coming, which is an
And
additional
I think
step
maybe there was
from
also an
the program of work.
amendment
There
to
is an
the
amendment.
program of work.
Right. And I think you're right. We have normally carried those together, so you could postpone this until the budget ordinance comes up for adoption at the next meeting.
And that would be the Resolution 202, not the one that's being added tomorrow, which I'm sorry, I don't
The
know
one
the
tomorrow
name.
has to lay over. It's going to be introduced.
Right, because those will be budget amendments.
Yeah, but that's a budget amendment for the current year, correct?
Yes, sir, and for 2013. So there'll be two.
After 2014.
2014.
Yes.
Right, 2013 and 2014. Correct.
But this 202 is just for 2014, so
Yes,
this
sir.
we could postpone until we do the rest of the budget. Great, thank you.
Any other discussion? If not, Mr. Sibley, let's proceed with introduction of ordinances.
Introduction of ordinances not to be adopted prior to December 10, 2013 includes number 149. It enacts Chapter 39 of the Code of Ordinances titled Human Relations relative to discrimination, definitions, and unlawful practices in connection with such discrimination, to provide for certain exclusions and to otherwise provide with respect thereto. Number 151 amends and reenacts Article 10 of Chapter 42 of the Code of Ordinances relative to charitable solicitation. Number 150 amends and reenacts Sections 10-172 of the Code of Ordinances relative to alcoholic beverages and to otherwise provide with respect thereto. Number 152 amends the 2013 general fund budget, appropriating the funds authorized therein. This is regarding IT. Number 153 declares a public servitude on certain adjudicated properties and otherwise provides with respect thereto. Number 154 creates an account for funds received through the FY 2012 Assistance to Firefighters Grant Program, Fire Prevention Safety Grant, and otherwise provide with respect thereto. Number 155 is zoning matter C8313. It amends Chapter 106 of the Code of Ordinances, City of Shreveport zoning ordinance by rezoning property located on the southwest corner of West 70th Street and Bernstein Avenue, Shreveport, Caddo Parish, Louisiana, from B3 Community Business District to B3E Community Business Extended Use District, limited to a compressed natural gas fueling station only. And number 156 is zoning appeal C7713. It amends Chapter 106 of the Code of Ordinances, City of Shreveport zoning ordinance by rezoning property located on the southwest corner of Emory Street and Hearn Avenue, Shreveport, Caddo Parish, Louisiana, from R2 Suburban Multifamily Residence District to B2 Neighborhood Business District.
Any discussion?
Mr. Chairman, on 155, is it somebody here from the fire department, Mr. Sibley?
Yes, sir. Tom? We have Assistant Chief Self.
Yes, sir. I hate for you to come up with Sam telling me to hurry up and get through.
Yes, sir, Mr. Sam.
I mean, Sam and Oliver. Would you make sure that these people abide by all safety rules?
What one you're referencing, 155, is that correct?
Yes, sir.
Okay.
The compressed natural gas station.
Yeah.
We certainly will.
Thank you. That's all.
Mr. Chairman,
Mr. Thompson.
a question, is 154 going to be removed?
We're going, yes, I'm sorry, because we're going to offer an amendment to the grants fund to handle that a different way.
And the other thing, on 156, Mr. Chairman, I believe Mr. Habit Scott will be here tomorrow to complain about the clerk of council and also to ask that this matter not be heard on the 10th because I think he's going to be out of town. And so the council may want to determine whether or not it will take this up on the 20th rather than the 10th, so that if you intend to do that, so that all of the parties will know and there won't, be any need for anybody to come down on the 10th.
There's 153 and 156. Are both of those related to what's happening at that property there? Should all of that be moved? And I have no objection to it being moved, to a more convenient date for all the parties. But when I was reading number 153, it seemed to have been related in some way to some activity on the same property.
I'm sorry, I haven't read it, so you're probably correct. I just didn't.
Well, I'll tell you what, when he comes down tomorrow, we just need to look at 153 and number 156, because 153 is asking for a servitude on the property that's being zoned at 156, and I'm thinking, based on some communications I've received from Mr. Scott, he has problems with all of this. Not to say that, that's how it's going to come out, but he seems to have problems with all of it, so.
And what I would ask too is that we keep in mind, as we're discussing with Mr. Scott tomorrow, the other landowner involved, I don't want to hold up
Right.
his process, you know.
Absolutely, and I agree
For too long,
100%.
so I think we'll have to find a way to balance that a little bit and see what's going on.
But I think they may be okay with an extension at least until the
But,
20th.
yeah, the last time I talked to the applicant, they seemed to be okay with the council taking it up on the 20th. But I don't know whether they'll be present tomorrow or not. I can try to contact them and see whether or not they can be present tomorrow. One of the problems that I had is that I couldn't just set it for the 20th, because if we put it on today, if it's introduced today, then the council could legally take it up on the 10th. So the only way that I could tell everybody was going to be taken up on the 20th is I would have at least 4 or 5 people who said that they would postpone in order to do that. And since there is time for the council to actually make a decision before that, I thought that that was a better way to proceed.
Right. Mr. Thompson, I don't think it necessarily means that the applicant needs to be here tomorrow, as long as if they're good with moving to the 20th.
That's the communication I received.
Any other discussion? If not, Mr. Sibley, let's move on to ordinances on second reading and final passage.
Number 143 amends the 2013 capital improvements budget. This is regarding Sportran. Number 144 amends the 2013 general fund budget. This is SPAR with some internal movement of funds. Number 145 amends the 2013 Community Development Special Revenue Fund budget. Again, some internal reconciliations. Number 146 revises, amends, and enacts Section 78-386 of the City of Shreveport Code of Ordinances relative to permit required fee, duration, waiver of that fee, and otherwise providing with respect thereto. This is regarding the Marine Patrol permits. Number 147 amends the 2013 capital improvements budget. This is regarding some airport taxiway projects. And number 148 repeals ordinance number 112 of 2013, which created a two-way stop intersection at Creswell Avenue and Southfield Road, and to enact the intersection of Creswell Avenue and Southfield Road as a four-way stop intersection.
Any discussion? Is there any table legislation that we may consider tomorrow?
Mr. Chairman, I think that based on prior conversations with the Mr. Sibley and staff, that the council can remove ordinances 113, 114, and 115. They have to do with the Street Special Revenue Fund. Sharika, is that correct?
Correct.
It's like 114 and
113, 114,
yeah, 113, 114, correct.
Okay. Just a little cleanup there.
Mhm.
Okay, perfect. We have made it through property standards appeals and ABO appeals. Mr. Thompson, I think that we do have one zoning appeal tomorrow.
That's correct.
And at this time, are there any reports from officers, boards, or committees?
I'll have a report on tomorrow, Mr. Chairman.
All right.
I'll make a quick report on a public safety committee meeting, and when we introduce the ordinances, I'll describe it further. But the meeting addressed both the let me find the actual legislation, just a moment. The ordinances 151 and 150. Those two, one is about charitable solicitation, and that was brought before the Public Safety Committee last week. Certainly some very valid concerns that we received from the police department in that regard, and we certainly agreed with their proposal, and you'll see that there in 151. And then 150 is in regard to we'll call it a 6-month trial basis for a group of lounges that are interested in serving alcohol on Sunday outside the entertainment district. But it is such a restricted area, and 8 or 9 establishments in close proximity, that the police department would like to assess it. They don't feel it can be treated as any other specific area in the city, and they'd like to just monitor it for a couple months and see if there's reason not to move forward with this in the more long term. So,
Perfect. Mr. Thompson, is there a clerk's report?
I think I just gave it, Mr. Chairman.
You have been very informative today. Mr. Thompson, a question for you. Do we adjourn this meeting and go into executive session, or we just make a motion to go into executive session?
Just make a motion when we get to that point.
Before we do that, I want to ask the administration a question. I was talking to Gene Eddy today. A passenger had called me requesting a stop location. But anyway, he had mentioned to me that the city of Bossier is talking very strongly about withdrawing their ridership from us, and they give us about $1 million a year. If they withdraw, what does do to our financial budget?
I think Dale and Gene are still evaluating that. I think specifically what they have indicated, Mr. Webb, council members, is that they want to do away with their evening and their weekend service. Haven't gotten an indication that they are looking to cut the entirety of it. But they want to do away with the night routes and the weekend routes. Obviously, that would be a revenue loss to Sportran, but also would be a reduction to some extent, and I think Gene and his folks are trying to figure out how to make it all balanced. We think it's unfortunate, because obviously Shreveport and Bossier, this region right now, is a 24-hour town. People who work second and third shifts now at a much higher rate than they did 20, 25 years ago. But again, we can't obligate them to not. But they're trying to figure out exactly what the ultimate implications would be, and hopefully not ultimately end up seeing it impact our operations on this side too negatively.
And if I may add, Mr. Mayor,
please.
Mr. Webb, Gene had made one meeting with them. He was scheduled to go back and meet with the mayor and the council, but that meeting has gotten pushed, so he's really waiting now while he does his internal assessment to go back and meet with them to see exactly what they want to do. But they did indicate they wanted to look at reducing some service, not eliminating it completely.
Okay. And I was going to ask our council attorney, I know everybody heard on the news where the gentleman, where a dead tree fell on a guy and it killed him. I get calls all the time. I'm sure some other council members have gotten calls from people that have dead trees in their yard, and there's nothing we can. There's no ordinance in place to do anything about that, and that brings to mind. Is there something we can do, an ordinance we can introduce, or is there something already in there when it comes to, let's say, a tree? Somebody has a dead tree on their property, and the neighbors are concerned it's going to fall on their house, and there ain't nothing you can do until it does. And it looks like there ought to be a way that we could force an owner of a property to remove a dead tree if it seemed to pose a safety hazard or something. Maybe that's something we should have brought up in the safety meeting. I don't know if that's ever been brought up.
It's tough. I know even on adjudicated lots where there might be a dead tree, that's a tough one to get somebody to act on, and I know I've run into problems with that.
We could look into that. Several things enter into it. First, I think you're talking about trees on private property, not on city property. So you'd be in a situation, I guess, maybe similar to property standards enforcement, where you're trying to enforce what someone does on their private property. There also are some civil code articles that make it, without us doing anything like that, make it a matter between the property owner and his neighbor or whoever the tree falls on. But we could look into whether there's something that we could do kind of along the lines of property standards. The other thing, I guess, that enters into it is we don't want to create any liability on our part for purporting to regulate it, and then what if we don't end up forcing it? So we can provide you some more
Yeah.
information on that.
Okay, thank you.
If there's no other questions or discussions, I will entertain a motion to move
So
into
moved.
executive session.
Second.
Motion by the Vice Chair, second by Councilman Oliver Jenkins. Please vote. And that is 7 yes.
Dale, did I hear you say that the pizzas will be on the way?
Not